Hello and welcome to the Brinks 2018 IP Developments webinar. My name is Whitney Bailey and I will be in the background answering any Adobe Connect technical questions. If you experience technical difficulties within the Adobe Connect session, please use the Q&A box on the right-hand side of your screen and our technical assistance team will help in any way possible. If you are having issues hearing over the phone, you may press *0 and an operator will assist you. Please note that as an attendee, you are part of a larger audience. However, to maintain privacy, the number and names of attendees will not be displayed. All attendees will be in a listen-only mode throughout the presentation, and as a reminder, today's call is being recorded. We will be holding a Q&A session at the conclusion of today's presentation. To submit a question, click on the Q&A panel located on the lower right side of your screen. Type your questions into the text field and hit send. Please keep the send to default as all panelists. This seminar is accredited for 1 hour of Illinois MCLE credit. Please inquire if you wish to seek CLE accreditation in additional states. During the webinar, we will be providing 3 CLE codes. Please write these down. We will be emailing an evaluation form at the end of the webinar and will ask for the codes. If you have any questions regarding CLE, please contact cle@brinksgilson.com. With that, we invite you to sit back, relax, and enjoy today's presentation. I would now like to introduce our moderator for today, Gus. Gus, you now have the floor.
Thank you. I'm Gus Siller. I'm the current president of Brinks Gilson Lione. I'd like to welcome everybody to this year's first webinar. Brinks is a firm that's been around for a little over 100 years. We celebrated our centennial year last year. We started with our headquarters here in Chicago over 100 years ago. We now have offices in 7 cities throughout the United States. And I'm happy also to say that last year we opened up our first international office in Shenzhen, China, which is a hub for research and development and technology. So with that, let me get started. Let me give a little background on the presenters today. We're going to have 4 presenters. Jennifer Fox, who is a partner in our RTP office. Jennifer has worked both in-house and as outside counsel, focusing in the pharmaceutical area, so she has a lot of expertise. She's going to be discussing today biosimilars and the industry developments in the recent years and going forward. Our second presenter is William Frankel, who's a senior partner, a senior litigator here at Brinks. He's also an expert on copyright law, so he will be presenting on development and strategies for copyrights going forward. And then we have a combined presentation by 2 of our rising stars here, Andrea Shoffstall and Alex Wang. We're going to be talking about 2 very important Supreme Court decisions that took place last year, and mainly their effects going forward. And that's the T.C. Heartland case, and then the potential impact of oil states with regard to future proceedings in the Patent Office. So with that, let me turn it over to Bill. Let me turn it over to Jennifer.
Thank you, Gus. So, as Gus mentioned, I will be speaking today on the topic of biosimilars. In the interest of time, we've kept this at a fairly high level. I understand that our audience is likely a mixture of technical backgrounds, so we will talk very briefly about the Act, but you certainly don't need an advanced degree in molecular biology to follow along. So just to start, biosimilars, people have probably heard at least the term floating around. It certainly made its way into the headlines quite a few times. But the approval process for biosimilars is in essence an approval process for sort of a generic version of a biological therapeutic as opposed to a small molecule therapeutic. And that was implemented in early 2010 when President Obama signed into law the Biologics Price Competition and Innovation Act, otherwise known as the BPCIA, from which you'll hear that referred to throughout the presentation. So the Act actually created sort of two types of biosimilars, and this is fairly different than what you'll see in a small molecule sense. So if you go to a physician and you have a sinus infection and they give you a prescription for, let's say, Ceftin, a brand name antibiotic, when you go to the pharmacist, you may actually find that you get a product in your hands for a lower price, and it's based on the side, generic for Ceftin. And that substitution can be made by the pharmacist. So you get the prescription from the doc, it says Ceftin, and that physician can substitute out a generic, provided the generic is properly rated. In the biosimilar space, there is a pathway for that called interchangeability. And interchangeability, very similar, a pharmacist would be able to substitute out a biosimilar for a particular branded product. However, we have not seen that particular status achieved by any of the approved biosimilars. Instead, what we've seen is what the FDA has called the highly similar products. And as you'll see on the slide, highly similar means exactly what it says, in the sense that it's highly similar in terms of purity, chemical identity, bioactivity, how it interacts with the patient, as well as no clinical meaningful differences such as changes in immunogenicity or side effects. So what I want to take away from this slide is really that this Act has created two types of biosimilars. The ones that we've seen are these highly similar or not interchangeable versus the interchangeable products. So as you can imagine, many applicants, of course, are trying to achieve interchangeability status, and we look to sort of what the FDA is doing to help these applicants get there. So in 2017, the FDA actually released a number of guidances, one of them being guidance for interchangeability. It's been out for about a year now, and we anticipate probably over the next year or two that you may see more applications looking for this particular status. In addition, the FDA released guidance on naming of biosimilars, which seems to be something that we say, well, of course, it's just a biosimilar for product X or product Y. But, of course, it can't be that simple. So as of right now, the non-proprietary name that you'll see here is filgrastim. Filgrastim is actually Amgen's Neupogen product, the Neupogen being the brand name. And Sandoz has a filgrastim that's a biosimilar, but it also has a brand name, the Rixo. But each of them actually gets this four-letter suffix that the FDA decided this is how we're going to differentiate between what is the, quote, brand and what is the biosimilar. So you'll see these seemingly meaningless suffixes on each of these products, regardless of whether they're the original innovator product or a biosimilar. So that was a pretty big advancement in 2017, is to figure out when these products are coming on the market, how do we actually identify them for physicians, for patients, and for pharmacists. What hasn't happened is what happens when we do reach interchangeability, whether the same rules should apply or not. So we may see that coming next year. But one of the other highlights from 2017 is that the agency actually approved 5 new biosimilars. So what you see on this slide is actually, as of today, 9 biosimilars have been approved by the FDA for marketing in the U.S. However, only 3 of them have actually been launched. So while we've made great strides in being able to get approval for products, there are a number of barriers to launching these products into the market. So one of the primary barriers, which we are going to talk about here, is actually outstanding patent litigation or other legal wranglings between the parties that is preventing these folks from coming to market. The other, however, like I said, we have the lack of interchangeability. And what this means is that even if there's approval and even if there aren't any legal barriers, the marketer of the biosimilar has a hurdle to actually get the physicians and the patients and the pharmacists to really take up the product. And since they can't substitute it, they actually have to be educated and become familiar with that product, similar to what the branded product had to achieve. So we'll talk a little bit about the sort of legal hurdles at first. And what we found in 2017, we had a lot of litigation with these first biosimilar applicants. But many of these cases were really focused on interpreting the act itself rather than the substantive acts of infringement, whether or not the product actually infringed particular claims. And instead we were focused on, what are all these provisions in the act? What are the notice requirements? What are the remedies for if you do or don't follow certain provisions? And in the interest of time, I'm not going to go into great detail, but at the end of this presentation and in the materials that you can receive after this seminar today, there is actually a sort of a quick reference guide to some of the sections of the Act. So some of the key points are the interpretation of the BPCIA when it comes to notice requirements and remedies. So the notice requirement is the biosimilar is required to let the reference product sponsor know, hey, by the way, I'm coming to market. And there's a provision that says you have to do that within 180 days. All the way to the Supreme Court, we found out that when that 180-day period begins was actually interpreted very differently by different parties, and the court decided that that can actually be given at any given time once they know that they will have commercial marketing and approval, and you don't have to wait until after approval. We also learned a little bit about remedies, when injunctions are available, or whether or not there's any state law remedies, and we'll go into this in some of the future slides. And there's also a bit on damages, which I think we'll see a lot more in 2018 on this aspect, that we did see the first decision, at least at the district court level, awarding damages equated to a reasonable royalty. We've also seen some settlements that may actually lead to additional launches. So the first thing that on the last slide that I spoke about was actually this notice requirement. And the notice is actually a 180-day notice, which seems to be fairly straightforward, but as with any new statutory scheme, there's always sorts of these gray areas, which lawyers, I think, see as opportunity. So anyhow, but the Supreme Court decided that 180 days could not result in additional market exclusivity. It, in fact, was simply notified within 180 days of commercial marketing. We also learned a little bit about the sharing of information provisions. The sharing of information provisions basically say that if you share your information, you're entitled to certain things, and if you don't share information, then the remedy is really going to be it's limited to what's in the federal statute, saying the reference sponsor can actually can actually bring a declaratory judgment action for infringement, but you can't actually go outside of that federal scheme, reaching under either safe harbor or actually reaching through to state law. And so the decision on whether or not you have a remedy outside of statute basically came back and said, no, what you have is you have the BPCIA, it covers all of your remedies, whether you have participated or not participated in a particular scheme, you're either going to have DJ jurisdiction or you're going to be able to file for injunction. That's it. If you try to actually go through state law, you're actually going to it was decided that the federal law preempted the state law. So looking at the damages claims, as I said, in 2017, this was the first damages award in this area, and it was actually fairly significant. A federal jury actually awarded Amgen $70 million in damages, finding that batches manufactured by a competitor, these were not actually sold commercially, but they're being prepared for commercial sale, were actually not protected under safe harbor provisions, and therefore the damages were a reasonable royalty for this period. Now, this was simply the original award, and Hospira has actually filed for a judgment as a matter of law, asking for review of both the safe harbor determinations as well as decisions on infringement and invalidity, and a review of the damages award. So that's a very quick view of some of the highlights of 2017. So what are we going to see for 2018? As I said before, 2017 was full of a lot of decisions around procedural issues that were raised with the BPCIA. 2018, I think we're going to see a lot more substantive decisions in terms of actual infringement or non-infringement, and whether or not there are damages awarded for certain batches, whether they're clinical batches or marketed batches. And as you can see, that these types of litigations tend to be very, very complicated. So we have Genentech, for the Herceptin product, there's 40 patents involved in that particular suit. Their product is Avastin, there's 24 patents involved in that suit. In AbbVie, we have 8 active, but there are actually 66 others identified that could be involved in the second wave of litigation. So these are very, very large, complex patent infringement cases that may take a number of years to settle out. But we'll actually see more of the substantive decisions, I think, coming towards the end of this year. And as to new launches, we know that there are a couple of settlements that may lead to launch. So the first one that I've listed actually we know is a 2023 entry. However, it has settled all outstanding litigation. And the other is we do know there's a license, we just don't know exactly when. So along with that, we have the actions by the FDA coming in 2018, and there's actually a focus to enhance the uptake of not only the approval process and make that easier to get through, but actually to encourage physicians and patients to take up the biosimilar as opposed to simply just taking the branded product. Of course, third-party payers are encouraging that sort of thing, and the current administration is also very interested in increasing price competition. So with that, I'm actually going to not comment on the last two slides, but these are sort of the quick reference slides that if you want to go back, this is a very complicated act with many, many sections in it. So there is a cheat sheet here that will help you refer to the individual sections that were cited in some of the decisions that were highlighted in this presentation. And with that, I will turn it back over to Gus.
Thank you, Jennifer. So the first CLE word, and it's important that everybody write this down, is developments, which is on your screen now. And with that, let me turn it over to Bill to talk about copyright cases.
Hello, everybody. My name is Bill Frankel. I'm going to speak to some copyright developments of late. There have been a number, but for purposes of today's brief presentation, I'm just going to talk about some copyright cases from 2017 and 2018, some decided, some to watch and keep on your radar screen. I'll first address the Star Athletica case, which was decided by the Supreme Court last March. Let me go to that slide. So the circumstances here was that there was a company by the name of Varsity Brands that designed and manufactured clothing and accessories for use in various athletic activities, including they made cheerleading uniforms. And Varsity received copyright registration for the two-dimensional artwork of what are referred to as chevron designs. They're depicted on the slide. And they got these registrations, and they sued a competitor, Star Athletica, for copyright infringement. Both parties filed motions for summary judgment. Star argued that Varsity did not have valid copyrights because the designs were for useful articles. Useful articles like clothing traditionally are not copyrightable. But Varsity said, well, we're not trying to register the clothing, we're trying to register the designs, which are separable and independent of the clothing, non-functional designs that are entitled to copyright protection. They're valid, and our copyrights have been infringed. So the issue presented was whether the lines, the chevrons, the colorful shapes appearing on the surface of these clothing articles were eligible for copyright protection. The district court said they were not and granted summary judgment for Star, but the U.S. Court of Appeals for the Sixth Circuit reversed, and Star appealed that, and in March of 2017, writing for the majority, Justice Clarence Thomas agreed with the Sixth Circuit, and as did 6 of the justices in a 6-2 ruling of affirmance. I think the takeaway that I'll leave you with this case before I move on is there was a dissent by Justices Breyer and Kennedy in which they observed that the original copyright applications included pictures of the cheerleader uniforms with the designs on them. And I think the takeaway from that I would offer you is that in the future, if you do have designs to register that are being used with useful articles or applied to three-dimensional objects, I would encourage you to register those designs independent of the article of manufacture. I think that would have gone a long way to helping Varsity in this case, but ultimately they did prevail. And it opens up, I think we're starting to see more copyright applications being filed with respect to clothing patterns, designs, and the like. The next case that I'd like to speak about is the BMG rights management case. This case has been going on for a while and was just decided by the Fourth Circuit this past week, and it's a pretty significant holding. The facts essentially were that BMG, which was a music company, sued Cox, which was an internet service provider, back in November of 2014 for alleged copyright infringement by Cox's users. The argument that was made at the time was that the Digital Millennium Copyright Act, the DMCA, as you know, has this safe harbor provision that protects internet service providers from secondary liability for copyright infringement based on things that are posted on their sites. But in order to avail yourself of that protection, you have to follow certain policies. And one of the policies in the DMCA is the repeat infringer policy, which says that an internet service provider must adopt and reasonably implement a repeat infringer policy. And the argument made by BMG in this litigation was that Cox had failed to do so. It turned out in that case that the judge, Judge O'Grady, agreed that Cox had not effectively implemented a repeat infringer policy and that it was not entitled to the safe harbor of the DMCA. As a result, the judge was given the instruction accordingly. What they were told was that Cox would be liable if it should have known that users were infringing. The jury went ahead to fine for BMG, and they awarded $25 million against Cox for contributory infringement. The Fourth Circuit affirmed the safe harbor ruling, that Cox was not protected under the DMCA. And that's the big takeaway from this case, is that now internet service providers have to be very mindful of their repeat infringer policies and make sure they don't turn a blind eye to copyright infringement, such as the peer-to-peer infringement that was taking place on Cox's site. Now, Cox had some bad documents. There were some bad facts for them here, but this is a significant ruling with respect to the repeat infringer policy. The other significant aspect of this ruling was that the silver lining for Cox is that the Fourth Circuit vacated the judgment against it for $25 million and remanded because the Fourth Circuit believed that the jury instruction on contributory infringement was inappropriate and wrong. The standard that was given to the jury, knew or should have known, of infringing activity was held to be the wrong standard, and the Fourth Circuit said that to prove contributory infringement requires proof of at least full blindness or knowledge of specific instances of infringement. So that's the test from the old Supreme Court landmark ruling in the Grokster case. It's also the test that's been adopted in patent cases like the Global Tech case. So the takeaway on this litigation, of course, is that repeat infringers means that you have to be mindful of what's happening on your site, and you have to take action, and you can't turn a blind eye. Otherwise, there's going to be significant potential liability, and service providers have to be mindful of that and careful about it. There's another significant case that's currently before the Ninth Circuit, and it's one that people in the software industry are watching very, very carefully. It involves something called APIs, which are a set of subroutines, protocols, and tools which make it easier for developers to build applications. Well, what happened here was, after negotiations fell through to license the Java code for use in developing software programs for its Android software, Google created its own Java-based programming where it borrowed some of the Oracle Java code and added its own code and to create the operating system for Android phones and mobile devices. Oracle sued Google for copyright infringement based on 37 Java packages that Google had copied from Oracle's Java platform. And Google admitted to the copying, but said that the codes, the APIs were not copyrightable. And there was a trial in 2011, and a jury found that Google was liable for infringing the copyrights. But the judge tossed that verdict out, ruling that the API elements were not copyrightable. And this went to the Federal Circuit. Oracle appealed. And Oracle won a high-profile reversal in May of 2014. The Federal Circuit said, yeah, these are copyrightable because there's different ways to express these various subroutines, and Java came up with one way of doing it, and there were other ways, and therefore this is copyrightable subject matter. The issue that remained at that point was whether or not Google's use of the code was a fair use. Was it fair use to use these APIs? And the case was remanded to the district court. District court found that this was a fair use, and now it's on appeal to the Ninth Circuit. So Google's argument, of course, is that just taking a small amount of copyrighted material, transforming it into a new mobile platform has a social benefit and was necessary so that people could access the non-protected functional elements of the code, and that's a fair use. Understandably, Oracle takes a very contrary position and says that this is creative, it's original. The Federal Circuit has already said that, and Google's use is undermining Oracle's ability to market the Java APIs in the market. So that's where that case stands. It has very serious ramifications, obviously, for developers. Will they or will they not be chilled in borrowing these APIs and creating new programs? That will depend in large part on what the Ninth Circuit does. So that's a case to keep your eyes open on. The next case I'm going to mention very briefly is the Fourth Estate public benefit case. The facts of this case aren't important. What's important is the issue. This is a case that's addressing the issue that there currently is a split among the circuits. You can see that split in this slide that's on the screen. The split is whether, in order to bring a lawsuit in the United States for copyright infringement, you need to have an actual copyright registration, or whether it's sufficient that you applied to register and or that you applied and were denied registration. So the circuits have split. This is an interpretation of Section 411A of the Copyright Act. And the circuits are split between the so-called registration approach and the application approach. And then there's half a dozen circuits that have yet to decide which way they're going to go on the issue. Well, this was an 11th Circuit case. The 11th Circuit favored the registration approach. Why is this case important? It's important because the case is on a cert petition to the Supreme Court, and the Supreme Court has requested comments from the Solicitor General. So we'll see if the Supreme Court ultimately takes this issue up and decides it once and for all. The last case I'm going to mention is a very interesting one in the music industry. It's gotten a lot of hype. It's the Blurred Lines case. And you may recall reading about this or hearing about it last year, where Marvin Gaye's heirs sued for infringement of the copyrighted song "Got to Give It Up," the famous Marvin Gaye number. Suit was brought against Robin Thicke, Pharrell Williams, and Clifford Harris for their immensely popular international sensation song Blurred Lines that came out in 2013. The facts here were not very favorable for Thicke and Williams. They had some bad facts, admissions that they made in the record on deposition, but notwithstanding, there were some serious issues about whether there was infringement, substantial similarity between the original copyrighted musical work and the accused work. The original work, as it turns out, was obtained under, the copyright registration was obtained under the 1909 Act, and so the registration and the protection was limited to the lead sheet music that was submitted to the Copyright Office. And the Gay estate wanted to rely on the sound recording itself and the groove of the music. They weren't able to do that, but they did introduce expert testimony that alluded to those things. And so ultimately, there was a $7.5 million judgment against Thicke and Williams from the jury. I think it was reduced to $5 million. Williams, Thicke, and Harris are appealing that now, and the issues are being watched by the entire music industry. The issues are, one, can a groove or a feeling in music be copyrighted? Two, what's the appropriate evidence to consider in these types of cases? In the Gay case, the music itself, all that was copyrighted was the lead sheet of the music. So is it even appropriate to address other issues such as the sound recording? And how do you analyze the substantial similarity of music, things like bass lines, melodies, harmonic structure, when the only protectable elements are contained in a lead sheet? So you got bad facts that kind of weighed against the defendants in this case, resulted in an adverse judgment against them, but you got some interesting legal issues about substantial similarity in music cases that are going to be very closely watched and will be very important decision out of the Ninth Circuit. Oral argument in this case took place on October 6, 2017, and we are waiting for a decision. And that's my whirlwind review of a couple of recent and important copyright decisions. I'll now pass this on to my colleagues.
Thank you, Bill. So the next CLE word, and this is important, is adjudicated. It's up on your screen now. And with that, let me turn it over to Andrea, who's going to discuss the effects of TC Heartland.
Thank you, Gus. Again, my name is Andrea Shoffstall. I am an associate here at Brinks Gilson Lione. I'm going to be discussing the first half of this presentation, the effects of TC Heartland. And my colleague, Alex Wang, will be discussing the second half. So before I get into the effects of TC Heartland, I wanted to give a little background on the law. So the TC Heartland decision issued in May of 2017. So it's been now about over 8 months. So I'm sure a large number of you are aware of the law and some of the legal history surrounding patent venue that led up to this decision. But I want to touch briefly on it for some of those whose practice maybe doesn't deal with patent litigation venue on a regular basis. So there are basically two statutes that deal with venue. However, over the years, there have been conflicting views over whether 28 U.S.C. 1400 is the exclusive statute for patent venue, or if it's to be supplemented by 1391C. So in 1957, the Supreme Court in Forco held that 1400B was the sole and exclusive provision controlling venue in patent cases, and that 1391C was not to supplement. And 1391C states, for those of you that are not familiar, that venue is proper wherever a defendant is subject to personal jurisdiction. Over 30 years later, Congress then amended 1391C, and then it stated for purposes of venue under this chapter, and the under this chapter language was the important issue there. So this change of language resulted in the Federal Circuit's holding 2 years later in the VE holding case that 1391C does in fact supersede 1400B. So a defendant is subject to, wherever a defendant is subject to personal jurisdiction, that's where they are deemed to reside, and that is where venue is proper. and the VE Holding case in 1990 remained controlling law on this issue for almost 27 years, and that's until T.C. Heartland. So after the T.C. Heartland decision, many defendants argued that they were no longer residing or they no longer had proper venue in their current venue because they were not incorporated there. However, regardless of whether or not venue was proper, in light of T.C. Heartland, a lot of defendants' motions to dismiss or transfer based on improper venue was denied based on the basis that defendant had already waived their right to challenge venue earlier in the case. However, after the In Re Micron decision in the Federal Circuit made it clear that T.C. Heartland is an intervening change in the law that excuses waiver for those defendants who no longer were in the appropriate venue according to T.C. Heartland. So another hurdle for defendants after the T.C. Heartland decision was whether or not the defendant had a regular and established place of business in the current venue. So while at first the requirements for this test were unclear, especially due to Judge Gilstrap's decision in the Eastern District of Texas, in which he laid out a 4-factor test for determining regular and established place of business, the Federal Circuit, in the appeal of that decision, provided some clearer guidance and said that the defendant has a regular and established place of business where there is a physical place in the district. That place is regular and established, not too clear there. And 3, it must be the place of the defendant. So those 2 major Federal Circuit decisions I just mentioned that provided some clear guidance in light of T.C. Heartland had some ramifications. So in addition to the T.C. Heartland's effect on changing where the majority of patent cases were filed immediately after the T.C. Heartland decision. I'll get into that a little bit later. With help from the Federal Circuit's guidance, the number of successful motions to dismiss or transfer rose. So now I'm going to get into the effects, including statistics surrounding T.C. Heartland and the United States District Courts and all the potential implications or some of the potential implications of this decision. So one of the effects of T.C. Heartland I mentioned previously is a change in where patent cases are filed. So to get a sense of the effect of T.C. Heartland and patent case filings, I consulted the Q3 and Q4 reports generated by Lex Machina. And Lex Machina conducts quarterly comprehensive analyses of litigation statistics. And as a part of its analysis, Lex Machina calculated that in the 90 days before T.C. Heartland, 33% of patent cases were filed in the Eastern District of Texas, whereas only 13% were filed in Delaware. Now, look at 90 days after T.C. Heartland, and the patent cases filed in Eastern District of Texas lowered significantly to 13%, while 26% were filed in the District of Delaware. So this major shift to Delaware is, of course, due to the fact that a large number of corporate defendants are incorporated in the state of Delaware. So regarding transfer motions based on improper venue prior to T.C. Heartland, 90 days prior specifically, only 40% were successful getting their cases transferred out of the Eastern District of Texas. And now we look at 90 days after T.C. Heartland, and the success rate rose significantly to 84%, and that's even taking into account those hurdles that I previously mentioned. In terms of the other district courts in the United States, their success rate varied as well, but it kind of depends on the district. So it's 48 to 70% success rate, depending on the district in the United States after T.C. Heartland. So as I've demonstrated in the last few slides, the Eastern District of Texas is no longer the #1 district for patent filings. Exemplifying this change is the fact that 432 cases in the second half of 2017 were filed in Delaware, and 261 were filed in the Eastern District of Texas. So again, the second half of 2017 would have been after the May 2017 T.C. Heartland decision. The chart that I have on this slide here shows the percent of patent cases filed from 2014 to the end of 2017, broken up into quarters. So as you can see, the number of cases filed in the Eastern District of Texas, which is the orange chart, the top chart there, went down in the second half of 2017. That's a pretty visible decrease, whereas Delaware and all other district courts went up. Delaware is the blue, and all combined district courts is the gray graphic at the bottom. So another interesting graphic shows the difference in where patent cases were filed in 2016 versus 2017. So as you can see, again, we have orange representing Texas, blue representing Delaware, and gray representing all combined district courts. So you can see the orange in 2016 was pretty high, far above Delaware for the most part, and about consistent with the rest of the district courts. In 2017, however, the first half remained consistent with 2016, but right at that point, on May 22nd, 2017, the T.C. Heartland decision, the Eastern District of Texas filings significantly dropped. You can see Delaware has been above them in most instances, and all other district courts have been much higher. Now, this third graphic shows the number of patent cases filed in 2017 and the top 15 district courts listed in the x-axis of this graphic, as well as the percent change in filings from 2016 to 2017. Again, you see a large 47.9% decrease or change in filings in the Eastern District of Texas, while you see District of Delaware getting a 71.1% increase. There are also some other district courts on the graphic that had a large increase, but I think it's important to note that those courts do not see as many cases being filed, which is represented by the blue bar above. So that large percent increase isn't necessarily an indication that, oh, these courts are being flooded with a ton of patent cases now. So another potential impact or effect of T.C. Heartland that we may see in the future is the overall patentee win rate in the United States. So although it's higher than the national average, the District of Delaware has a lower patentee win rate than the Eastern District of Texas. So due to the shift in the number of patent cases being filed or being transferred from the Eastern District of Texas to Delaware or other districts, we may see a lower patentee win rate overall. So that's something we may want to monitor over the next year or so, and something for patentees to keep in mind as well as defendants. So an additional effect may be a decrease in NPE or non-practicing entity suits. According to the National Law Review, 38% of the Eastern District of Texas decisions from 1997 to 2016 involved NPEs. And those NPEs had a 49% success rate in the Eastern District of Texas. So we may see a decrease in the success rate potentially, and then I think we'll definitely see a decrease in the number of NPE suits in the Eastern District of Texas. And lastly, another possible effect or implication of T.C. Heartland is that on the local economies of the surrounding areas of the district courts. For example, the decrease in patent cases filings in Eastern District of Texas is significant, as you've seen throughout my last few slides. It has yet to be seen whether this is going to result in significant harm to the local economies. But one attorney from the Eastern District of Texas that I have highlighted here is not convinced that it will. Michael C. Smith of Seidman, Berg, Phillips, and Smith stated that the idea that the local, and again he's referring to the Eastern District of Texas divisions, economy is driven by an extra half dozen one-week patent trials a year is a myth. Locals are far, far more interested in the price of oil, which still drives the local economy. So it'll be interesting to monitor the local economies of those district courts that have seen a sudden boom or are now busier in their courts. Perhaps Mr. Smith's prediction will prove to be true, but only time will tell. So with that, I'm going to pass the torch on to my colleague, Alex Wang, who will be discussing oil states.
Thank you very much, Andrea. Thank you, the audience, again, for joining us today. My name is Alex Wang. I'm an associate at Brinks Gilson Lione. I'd like to introduce and give you an update about oil states, which is a huge case currently pending a decision from the Supreme Court about the constitutionality of the IPR proceeding, the inter-party review proceeding in the Patent Trial and Appeal Board. So the procedural posture of oil states. Oil States Energy Services sued Green's Energy Group for patent infringement in the Eastern District of Texas. And Green's Energy Group filed an IPR petition challenging certain claims of the asserted patents. Later, the PTAB found all of the challenged claims unpatentable. Oil States then appealed to the Federal Circuit, arguing, among other things, that the Constitution requires patent invalidation to be determined by a jury in Article 3 court. As a side note, which I found very interesting, that Oil States did not specifically object to the constitutionality of IPR proceedings during the IPR review. And its notice of appeal to the Federal Circuit also did not specifically identify the constitutionality of IPR procedure as a specific issue. Nevertheless, the Federal Circuit took the appeal and then affirmed the decision of the PTAB in a Rule 36 decision, which provides no written opinion. And subsequently, the Federal Circuit denied Oil States' requests for panel rehearing and a rehearing en banc. However, the Federal Circuit previously reviewed the constitutionality of IPR in MCM portfolio versus HP. In that case, the Federal Circuit concluded that patent rights are public rights, and their validity are susceptible to review by an administrative agency without a jury. And the Supreme Court actually denied cert in MCM. And then after the Federal Circuit denied its request for en banc rehearing, Oil States filed its petition for cert on November 23, 2016. On June 12, 2017, the Supreme Court granted cert, which is limited to the first question presented in the petition, namely whether inter partes review violates the Constitution by extinguishing private property rights through a non-Article 3 forum without a jury. Given what's at stake and the potential impact of the issue, 57 amicus briefs were filed, including 21 in support of the petitioner, 26 in support of respondents, 10 in support of neither party. And before Oil States, the Supreme Court actually has denied cert in several petitions challenging the constitutionality of IPR procedures. Nevertheless, the Supreme Court's decision to grant cert in Oil States followed shortly after the Federal Circuit's denial of en banc review in Cascades Projection versus Epson America. In that decision, the appellant also raised the constitutional challenge to the IPR proceedings, and multiple opinions were issued in conjunction with the denial of en banc review. Judges O'Malley and Reyna issued dissents from the refusal to have the entire Federal Circuit rule on the constitutionality of IPR proceedings. So on November 17, 2017, the parties in the Oil States versus Greens Energy completed briefing with the key issue being focusing on whether patents are quintessential public rights, such that IPR can be justified under the public right doctrine, which were based on Supreme Court precedents. And that doctrine allows Congress to assign certain public rights for adjudication in non-Article 3 tribunals. Now let's turn to what happened in the oral argument. The oral argument in front of the Supreme Court in the Oil States case was held on November 27, 2017. And various points were brought up, and both sides got hard questions. The oral argument actually presented more questions than it answered. Although the former interim PTO director, Joseph Mattel, predicted before the oral argument that the Supreme Court would issue a unanimous decision upholding the constitutionality of IPR proceedings, after the oral argument, it seems unlikely based on the split between the justices. And the feeling among practitioners in general is that it is unlikely, though still possible, for the court to strike down IPR entirely. But it's more likely that the court may put up some limits on the application of IPRs. So that's turn to what are the key issues focused on during oral arguments. One of the issues that drew attention of Justice Ginsburg, Sotomayor, and Kagan is the distinction between reexamination proceedings, including both the ex parte reexamination and inter partes reexamination, and the IPR proceedings, and why IPR is not simply an error correction mechanism. And the petitioner focused on the argument that the IPRs are just too adjudicatory and not examinational in nature, which, from my reading of the transcript, wasn't really bought by Justice Ginsburg and the Sotomayor. And another issue that was the theme throughout our argument is whether patents are public rights or private rights. And I believe Justice Kennedy, Justice Sotomayor, and Justice Gorsuch all chipped in on this issue. In particular, Justices Sotomayor and Gorsuch both raised the question that why does the adjudicatory nature of the IPR matter if patents are public rights or are private rights? And the third issue that drew attention of Chief Justice Roberts and Justice Gorsuch is that whether there is any due process concern in view of the evidence of panel stacking in the PTAB and the need for judicial review. Chief Justice Roberts also raised question about whether it's appropriate to apply IPRs to patents issued before the AIA, which established the IPR proceeding in the first place. And another issue that concerned Justice Breyer, Chief Justice Roberts, is whether a patent owner gains a vested interest after enough time goes by and sufficient reliance, such as in the form of like huge investments. With these 5 issues in play, some of the issues raised in the petition were not actually discussed in the argument. For example, the 7th Amendment right to a jury trial were not really brought up in the argument. Also, although the parties devoted a lot of pages to the old history of English law and what happened in the English courts about adjudication of the validity of patent rights, those were not discussed in the oral arguments. Finally, let's talk about potential impact of this case. So for concluded cases, which means the cases that already completed all the review based on a previous Supreme Court decision, Harper versus Virginia Department of Taxation, at least one district court has interpreted Harper decision to mean that even if the Supreme Court held that the IPRs are unconstitutional, that decision won't affect any cases are no longer on direct appeal. And for currently ongoing cases, the Federal Circuit has rejected patent owners' motion to stay appeals pending the determination in oil states. And the PTAB has similarly denied patent owners' request to file a motion to stay ongoing IPRs in view of oil states. However, for patent owners who wish to benefit, who have a proceeding currently pending in front of the PTAB or the Federal Circuit who wish to benefit from a favorable decision in oil states should nevertheless preserve their objections on the constitutionality issue. Lastly, what would the potential impact going forward if in the event that the Supreme Court decides that IPR is unconstitutional? One, the main forum, as predicted by many practitioners, for determining patent validity would return to district courts, just like a few years back before the IPRs are established. And then the CPM proceedings which were created in the AIA at the same time with IPRs, will likely face the same constitutionality challenge down the road. And then the NPEs that were inactive due to the threat of patent invalidation in IPRs and maybe CBMs may become active again. Also, patent owners may seek to exercise their rights and to monetize their portfolio more aggressively, because when turning back to the district court litigation, there is a higher standard of proving invalidity than the PTAB, and the patent owner may take that as a leverage in both exercising their rights and to gain leverage in licensing and settlement negotiations. And for that, I turn back to Gus.
Thank you, Andrea and Alex. Just for everybody's note, the third CLE word is impact, which is up on the screen. And we'll take some questions. I see we have some questions here. This one is for Andrea. So it's noted that your chart showed that there was a significant decrease in filings in the Northern District of Illinois. Is the decrease in filings attributable to TC Heartland?
Thank you, Gus. That's a good question. Without doing a complete analysis of the Northern District of Illinois and other potential factors that may be playing into the decrease in filings, I wouldn't say it was solely attributable to TC Heartland. However, I could see that being the major reason behind the decrease in filings in the Northern District of Illinois. Again, I see it's from 2016 to 2017. So I can't imagine that would have been a preemptive decision by people filing patent suits to not file in the Northern District of Illinois, anticipating the TC Heartland decision. So I'm sure that there were other factors playing into that as well.
Thank you. One more question on TC Heartland. What factors have driven the Delaware win rate to 41%, which is higher than the national average?
Without, again, having a complete analysis on all of that, Delaware just has tended to be patentee friendly over the years, and that's just something that we've seen with respect to jury verdicts and the results coming out of the Delaware District Court.
Okay, and Andrew, you're the winner here. You get one more question. So you discussed the effects of TC Heartland on the U.S. District Courts and U.S. corporate defendants. What effects or potential effects do you think TC Heartland will have on foreign corporate defendants?
Thank you, Gus. So actually in TC Heartland, the court declined to address foreign corporate defendants. So TC Heartland actually really doesn't have an effect on foreign companies. So a plaintiff who wants to file a patent infringement suit against a foreign corporation can probably still establish proper venue. Potentially some cases may come out in the future, changing this law a little bit, but wherever the foreign defendant is subject to personal jurisdiction, venue is proper.
Thank you. That, I don't see any further questions. I thank you all for attending. Hopefully this was informative, and we'll see how all of these issues play out in the upcoming year.
This does conclude today's presentation. You may disconnect at any time.